Imagine this. Federal money for your kid's school suddenly at risk. Not because of budget cuts, no, but because the U.S. government is challenging state policies, things like student privacy, even what sports kids can play. It's a pretty high-stakes reality right now for states like California. And really, this isn't just about the dollars and cents, is it? It feels like a deeper constitutional challenge, maybe reshaping how education is governed in the U.S. So today we're doing a deep dive into this complex legal and financial standoff, federal government versus states. We'll look at a recent Supreme Court decision, billions of dollars literally hanging in the balance. Our mission here is to unpack the core arguments, try to clarify the legal ideas in play, and maybe most importantly, understand what this all means for you, for your community. Because these decisions, they land right in the classroom.
It's a really critical moment, absolutely. And it highlights this ongoing tension, doesn't it, between federal control and state control over education. We're seeing the federal government actively use its financial power, leveraging it to influence what states do. And that's leading to these pretty significant legal fights.
Okay, so when we talk about federal funds being at risk, what's really at the heart of it? Is it just rules clashing with policies, or is there more going on? Let's start with the Trump administration's position. Back on February 5th, 2025, the Department of Education put out this directive. Pretty clear language. It required staff to review issued grants, make sure they do not fund discriminatory practices, and also check for fraud, abuse, and duplication. What was the key thing there, do you think?
Well, what really stood out about that directive was how explicit it was. It actually specified that these reviews would cover practices in the form of diversity, equity, and inclusion, DEI. So when the termination letter started going out, they actually said it conflicts with the department's policy of prioritizing merit, fairness, and excellence in education. It wasn't exactly subtle. It was a very direct signal about, well, reprioritizing how federal education money should be used.
That definitely sounds like a significant shift, almost ideological.
Yeah.
And it wasn't just DEI, was it? We saw similar things happening with sports programs, too.
Precisely. Around the same time, in February, the administration also issued a directive threatening to pull federal funding from schools, schools allowing transgender women or girls to compete in female sports. Their argument, is that these actions are needed to uphold federal anti-discrimination laws and to make sure the funds serve the best interests of the United States. It's a broad view of how federal money should be directed, and it has real consequences for schools on the ground.
Okay, so that's one side, this strong federal stance. What about the states? How did they react, particularly California? They seem to be right in the middle of this.
California really has become a sort of focal point for the pushback.
Yeah.
On July 17th, 2024, Governor Newsom signed the Safety Act, Assembly Bill 1955. And this was pretty groundbreaking, actually. It prohibits schools from requiring teachers to tell families if a student changes their gender identity. Made California the first state to legally ban those kinds of notification mandates locally. It's a direct counter to the federal government's preferred approach on parental notification.
A very strong move.
Yeah.
And it definitely stirred things up immediately. Critics like the Center for American Liberty, Chino Valley Unified School District, they came out strongly against it. Their claim is that the law obscures parental engagement, violates parental rights protected under the U.S. Constitution, and essentially lets schools push what they call radical gender ideology without parents knowing. How do they actually define that term, radical gender ideology?
Yeah, that's a key question. For those critics, radical gender ideology generally refers to their concern that schools might be actively affirming or even promoting gender transitions for students, and potentially doing so without parents knowing or consenting. They see laws like AB 1955 as undermining what they believe is a parent's fundamental right, the right to direct their child's upbringing, their education, especially on really personal things like gender identity. It's important to understand that viewpoint because it really drives their legal challenges.
Okay, that helps clarify the opposition. And California's position on transgender students in sports, it wasn't new either, was it?
No, not at all. California's had a state law on the books since 2013. It explicitly allows transgender K-12 students to compete on teams that match their preferred gender. And we've seen this play out, in high-profile situations, like the case of A.B. Hernandez, a transgender athlete who won medals at the state track championship. The California Interscholastic Federation even came up with this unique policy for award sharing, where she shares her award with any biological female she beats. It just shows how specific and, established some of these state policies already were.
Right, so you've got these federal directives pushing one way, states like California digging in and pushing back.
Right.
What was the immediate result for schools across the country, really?
Well, the Department of Education didn't waste much time. They started terminating over 100 grants. These were for important programs like the Teacher Quality Partnership, TQP, and the Supporting Effective Educator Development Program, SEED. But the really striking thing was how they did it. They used this sort of generic boilerplate language, no specific reasons given for each individual grant termination. It just left a lot of states and schools kind of scrambling, facing these big funding gaps without really knowing why.
And when money gets cut like that, suddenly, without a clear reason, what can states even do? Sounds like it ends up in court.
Oh, absolutely. That's exactly what happened. On March 6th, 2025, 8 states, California included, filed a lawsuit. They sued the Department of Education in a Massachusetts district court. They argued these mass terminations violated the Administrative Procedure Act, the APA, basically saying the government acted arbitrarily and capriciously, meaning, without a good reason or proper process. Their goal was pretty clear: stop the terminations, keep the funding flowing.
And the district court moved fast on that, didn't they?
Amazingly fast. Yeah, just 4 days later, March 10th, the district court issued a temporary restraining order, a TRO, sided with the states. That order put a temporary stop to the terminations and, crucially, required the government to keep paying out the money. The court said the states were likely to succeed on the merits of their case. That TRO then got extended until April 7th. It was a big, albeit temporary, win for the states.
But the Department of Education, they didn't just roll over, they took it higher.
Yeah.
Straight to the Supreme Court.
That's right. On March 26th, they appealed directly, asked the Supreme Court to vacate the TRO, essentially, cancel the lower court's order. And the Supreme Court acted quickly, too, ruling on April 4th. The majority, they looked at the TRO, decided to treat it like a preliminary injunction, a sort of stronger temporary order, and then they granted a stay, which basically allowed the grant terminations to move forward again.
Okay, this is where the legal stuff gets a bit dense, but it's so important. The Supreme Court majority, they didn't actually rule on whether the DEI policies or transgender policies were right or wrong, did they? Their decision was about something else entirely. Jurisdiction. Can you unpack that? Why did they rule that way? And what does it mean for states trying to get that funding back?
Absolutely. And you're right, this is key. The court's decision wasn't about the substance of the policies. It wasn't a judgment on whether the DOE should have canceled those grants. It was really a powerful lesson in legal procedure. Sometimes how you sue matters just as much as what you're suing about. The majority argued the district court likely didn't have the proper jurisdiction, the authority under the Administrative Procedure Act, the APA, to order the government to pay money. They reasoned that the APA's permission for the government to be sued what's called a waiver of sovereign immunity. Well, that waiver doesn't apply when the main thing you're asking for is money damages or trying to enforce a contract to pay money. For that kind of claim, they said, there's a different path. You need to use the Tucker Act, which sends those kinds of contract-based lawsuits against the U.S. government to a special court, the Court of Federal Claims.
So essentially, the Supreme Court was saying, you might have a case, but you're knocking on the wrong door if you want your money back right now. And they also seem to imply the states weren't facing, truly irreparable harm from the cuts. Is that fair?
That's pretty much it. The government had argued it would be hard, maybe impossible, to get the grant money back once it was paid out. And they pointed out the district court hadn't required the states to post a bond, like a financial guarantee. The Supreme Court majority kind of echoed that. They suggested the states have the financial wherewithal to keep their programs running anyway, and that they could potentially get the money back later through the appropriate forum, meaning, likely, the Court of Federal Claims. The implication, maybe a bit harsh, was that if the states suffered irreparable harm because programs stopped, it would be, quote, of their own making if they didn't find other ways to fund them while the legal process played out elsewhere.
Wow. That sounds incredibly complicated for, a school district just trying to figure out its budget for next year.
Mm-hmm.
I bet there were some strong disagreements on the court about that.
Oh, definitely. The dissenting justices made a few key points. They argued the Supreme Court jumped in too soon, that it was premature. They also pointed out that the government hadn't really defended the legality of canceling the grants based on the actual policies involved. And crucially, they highlighted the very real, concrete damage already happening. They mentioned Boston Public Schools had already fired people because of the funding cuts. California State University had ended support for 26 students, cut financial aid for 50 incoming students. These weren't just abstract harms, they were immediate, tangible impacts.
The sheer amount of money involved is just staggering. When we talk about a state like California, how much federal funding are we actually talking about? What are the real stakes here?
These stakes are just immense. I mean, federal funds make up more than a third of California's entire state budget. That's estimated around $170 billion a year. It's a huge amount flowing into everything: infrastructure, social programs, everything.
And specifically for schools, for education. What does that number look like? How much is really hanging in the balance for kids and teachers?
For education, the figures are stark. You're talking billions in federal dollars supporting really crucial services across California. Over $2 billion every year just for Title I schools, those serving low-income students, often the most vulnerable, and over $1 million for special education services for kids with disabilities. The California Teachers Association even put a number on it. They said $3.43 billion in federal funding for special ed and school meals is now in jeopardy. Cuts like that, well, they blow massive budget holes in state and local finances. It would force really painful spending cuts, putting essential services for millions of students and families at risk. It's not just numbers on a page, it's classrooms, teachers, support staff.
Those financial numbers are overwhelming. But they also force us back to basics, right? Like, where does the federal government even get the authority to attach conditions to its money like this? This gets us right into the spending clause of the Constitution, doesn't it?
It absolutely does. This whole situation really spotlights these core constitutional principles, especially the spending clause. That's in Article 1, Section 8, Clause 1. That clause gives Congress the power to spend money for the general welfare. It's the basis for the federal government imposing conditions when it gives money to states. It's a huge power, but importantly, it's not unlimited.
Right, so Congress can attach strings, but the Supreme Court has said there are limits. How tight can those strings actually be? Can you walk us through those limits? Cases like South Dakota v. Dole and NFIB v. Sebelius seem key here.
Yes, the court has definitely put up some guardrails. There are basically four main rules for these spending conditions. First, the conditions have to be unambiguous. States need to know exactly what they're signing up for. Second, the conditions need to be germane, related to the purpose of the federal money. You can't just attach unrelated conditions. Third, the conditions can't force states to do something unconstitutional. And fourth, and this is probably the most relevant one right now, the financial incentive can't be coercive. It can't be like a gun to the head, leaving states with no real option but to acquiesce.
That coercive point feels critical. How have the courts figured out what crosses the line into coercion?
Well, that's where the NFIB v. Sebelius case, the one about the Affordable Care Act, is really helpful. In that case, the court said threatening to take away all of a state's Medicaid funding, which was about 10% of the average state's budget, was unconstitutionally coercive. They contrasted that with the Dole case. There, withholding just 5% of highway funds from states that didn't raise the drinking age was not seen as coercive. So it creates this kind of spectrum. The big question now is, considering the billions at stake for education, are the current threats from the administration specifically tied to DEI or transgender athlete policies? Are they germane to things like Title I funding or special ed? Or are they crossing that line into impermissibly coercive territory, pushing states too hard, constitutionally speaking?
Which brings us sort of full circle to the bigger political picture. It really sounds like this is more than just money or legal details. It sounds like a proxy fight in the larger culture wars, right? Playing out right in our schools.
That's exactly right. This conflict really is a deep federal-state power struggle, and it's focused squarely on education policy and civil rights issues. You see the Trump administration quite openly using federal funding as a leverage point to enforce its conservative agenda on things like DEI and transgender rights. It's a very clear strategy.
And how are the states on the other side viewing this? Places like California, Minnesota, New York, Illinois, Vermont, mostly Democratic-led states. What's their take on this federal pressure?
Well, they see it as major federal overreach, intrusion into areas they believe should be controlled by states and local communities. They argue it violates basic principles of federalism. So they're pushing back hard, asserting there's nothing illegal about DEI programs, for instance, and directly challenging the federal government's legal right to impose these kinds of conditions. It's a fundamental disagreement over who gets to decide what happens in local schools.
So you've got the executive branch using its power, states pushing back, the judicial branch trying to referee. It's really a textbook example of how our system of checks and balances is supposed to work, or maybe how it sometimes clashes.
Exactly. The executive branch, the administration, the Department of Ed Gray, they set policy, they use funding as leverage. Then you have Congress, the legislative branch, which ultimately holds the purse strings. They authorize the grant programs, set the broad terms. And then the judicial branch, the courts, they step in to interpret the laws, the Constitution, review what the agencies do, rule on jurisdiction. Just like we saw with the Supreme Court stepping in here, each branch has a distinct, powerful role in this whole dynamic.
And the economic fallout, it goes beyond just the school funding itself, right? It's not just about the school's budgets.
Not at all. I mean, think about Elon Musk publicly threatening to move SpaceX and X headquarters out of California. His stated reason was the state's new law protecting student gender identity privacy. It just shows how these policy fights, often rooted in these cultural divides, can spill over and have much wider economic impacts, affecting a whole state's business climate, jobs. These battles aren't just happening in school board meetings.
Okay, so let's try to recap this deep dive. We've looked at this really intense federal-state power struggle over education money. It's driven by very different views on policies like DEI, transgender student rights. The Supreme Court has gotten involved, not really deciding on the policies themselves yet, but definitely setting some boundaries on how these fights play out legally. It's complex, layered, and it affects, well, everyone from the federal government down to local communities.
Right. And this legal and financial chess game, it's about more than just budgets. It really asks a fundamental question. Who gets to decide the values that shape our schools, that shape our kids' future? What's the right balance between what the federal government wants and what states want to do, especially on issues that are so personal, like identity, like parental involvement? This tension, it's not going anywhere soon.
So as these battles keep going, maybe the critical question this deep dive leaves you with is this. Beyond the court decisions, beyond the budget lines, what's the real long-term cost to states, to local communities, and especially to the students they serve? What's the cost when these fundamental disagreements over core values keep happening at the highest levels? What kind of future are we actually building for our kids as these forces clash?